Hey everybody, John Skiba here from the Consumer Warrior YouTube channel. And in this video today, I'm going to talk about the differences of being sued by an original creditor as opposed to being sued by a junk debt buyer. This is going to make a whole world of difference in how you approach defending this type of lawsuit, how you can resolve it, how you can settle it, and how you can get a better deal overall. But if this is your first time here to my YouTube channel, please go ahead and click subscribe. Check on that little bell. That way you'll be notified each and every day when we put out new videos that'll help you deal with serious debt problems. All right, let's talk about debt collection lawsuits. Now, if you find yourself in a situation where you're being sued by one of your creditors, this distinction that I'm going to talk about, whether you're sued by the original creditor or a junk debt buyer, understanding the difference between the two and the different approaches you can take is going to make a world of difference as far as how you can get the case settled, resolved, and in the rearview mirror once and for all. Now, let's start with original creditor lawsuits. And the way you can know this for sure is take a look at the complaint or the petition or the summons, the document you receive from the process server or from the court. At the top of the first page, there is what's known as the caption. You'll see this has like plaintiff versus defendant. The defendant will be you, the consumer in the case. The plaintiff is the creditor, the junk debt buyer, the credit card company, the bank, whoever it is who's claiming that they are owed money. Now, if the plaintiff is listed as the actual bank or credit card that you actually had, then you know you're being sued by an original creditor. For example, the most common type of original creditor lawsuits that I see here in my law practice in Arizona is creditors like American Express, Bank of America, Capital One. Those types of creditors often do not sell their debt to third parties, but they keep it in-house and they file their own lawsuit. And to kind of get a better understanding of how this whole system works, we have to take a couple steps back. So when you stop making payments on your credit card, what'll happen? You're going to start getting phone calls. You're going to start getting collections. You're going to start getting emails and letters. All these things are going to start going into motion. You may get calls from the original creditor. They may hire a collection agency to actually start calling you and harassing you to try to get you to pay. Once you hit 180 days of no payment, so a full 6 months, that's by law when the creditor is required to charge off your account. Now, over the years, I've gotten all kinds of hate in the comments when I talk about charge off, because a lot of people believe that the charge off means that the creditor can no longer collect on the debt. 100% not true. Even if it's charged off, the creditor can still try to collect on the debt. All a charge-off is, it's an internal classification as far as the company, the bank treating it as a loss on their books. It has nothing to do with whether the debt is actually collectible or not. Some people will say to me, oh, that means insurance has covered it. I can tell you there's no insurance. They're just counting it as a loss on their books, but they can still try to get you to pay. Now, if it's an original creditor, what they will often do is continue their own internal collections. They may reach out to a third-party debt collector or a collection agency, so they're not actually transferring ownership of the account, but what they're doing is hiring another company to be the one that calls you and harasses you and gives you all kinds of grief. But they also may eventually decide, hey, we're going to sue you. And so they may hire a law firm in your local town and they may file a lawsuit against you. Now, if you look at that, again, the complaint or the petition, the summons, and you see, hey, that was my American Express is suing me and that's why I had the credit card through, you know you have an original creditor lawsuit. Now, the reason why this is important, because the number of defenses you have are much less when the original creditor is suing you. The reason being is we can assume that they're going to have the documents, the witnesses, all the evidence they need to be able to establish that you are liable on the account and how much you owe. Now, the reason why we assume this is because these are their accounts. You're assuming that they have everything in-house. They don't have to go to a third party to get it. They don't have to go find third-party witnesses. Everything is there for them to be able to prove their case. Not only that, but they are going to state that, that they have suffered a direct loss from the non-payment. So again, if you owe American Express $10,000, you default on it, they aren't going to settle for as low as amount as a junk debt buyer will, because they're going to say they sustained the full $10,000 loss. In my experience, the original creditor is more likely to settle for 50 to 80% of the total balance as opposed to a junk debt buyer who'll sell for much less. So we're going to talk about how much less in just a moment. But the way that I typically approach original creditor cases, I still recommend filing an answer to the complaint. The reason is you don't want a default. A default judgment means wage garnishment, bank levy. They could lien real estate. Filing an answer also allows you to get documents. You're going to be able to see exactly what they do have to see if there are any defenses, and it's going to buy you some time. And it provides you an opportunity to negotiate with the attorney of the original creditor to hopefully get a deal in place and avoid a judgment altogether. Now, if the original creditor, many of them after that 180 days prior to charge off, when they do charge it off, they will then sell your account. They'll package it up in a bunch of portfolios and they'll sell your account to third-party junk debt buyers. Now, junk debt buyers, the big ones out there are Midland Funding, LVNV, Resurgent Capital, Unifund, Portfolio Recovery Associates. If you get out the complaint to the summons and you see one of those names in there, that's when you know that you're dealing with a junk debt buyer. Now, the junk debt buyers, they pay, there was an FTC study that once said that they pay on average 4 cents on the dollar. So for every dollar of debt that they purchased, that the original creditor's claiming owed, they paid 4 pennies to the original creditor for that. Now, they buy it at such a discount because there's a lot of risk for them. You know, these are already debts that have not been paid, and there's a high risk that they may continue to not be paid. But what they're taking the gamble on, they're going to buy it at a discount, and if they can prove that they're the owner of the debt, even the courts will allow them to collect 100 cents on the dollar. So their bet is, hey, we're going to be able to collect on this, and hopefully the full amount, which would be, 96% increased profit for them in going forward. And so, but the issue is when junk debt buyers, when they buy these debts from the original creditors, it's surprising how little information they actually get. They often have a spreadsheet with a bunch of names, addresses, account numbers, and the alleged balance owed. They often don't have what they call media, which is their monthly statements, specific chain of title documents. And because of that, there are many more defenses to these types of cases. When a junk debt buyer files a lawsuit against you, they have to prove everything that the original creditor does. They have to prove that you had the account. They have to prove that you breached the contract. They have to show what the terms are. They have to show what the balance is and how they calculate it. But on top of that, they have to show that they bought your specific account. They have to show that they have standing to pursue this. And this makes sense because you're being sued by a company you never agreed to pay money to. They didn't loan you any money. And so there's no what we call privity of contract between the parties. And so they have to establish that. They have to prove that they are actually entitled to payment and that they actually received this debt or they purchased this account from the original creditor. Now, surprisingly, this is where they run into trouble. When a junk debt buyer files suit, they will often include what's called a chain of title document. Now, the chain of title is where they're saying original creditor sold it to junk debt buyer, and here's the accounts that were sold. It's often very surface level. They often will show large portfolios, but they don't reference your account specifically. And that's what they have to prove. They don't just have to prove that a big pool of accounts were sold from credit card company to junk debt buyer. They have got to be able to prove that your specific account was transferred between these entities, and they often struggle to do that. Now, not only do sometimes creditors, original creditors, sell their debt to junk debt buyers will often sell it to other junk debt buyers. I have seen cases where it's been sold 4, 5, 6 different times. And the reason why that's important is because the chain of title, the more times it changes hands, you'll see the more often it's difficult for the junk debt buyer to be able to actually establish ownership. Not only that, but the further it goes down the line, usually the less they have paid for that particular account, and so they're willing to settle for much less. Because of this, I see junk debt buyer cases where they will settle for as low as 15 to 20% of the total original balance up to about 35 to 40%. So they will take much less because they don't have as much invested as the original creditor. So these types of defenses are there and they exist with a junk debt buyer lawsuit when you don't have them with the original creditor lawsuit. So if you're getting sued by the actual bank that you had the account with, I always say it's always good to file an answer. That way you stop any type of default, you stop any type of attorney's fees, all that kind of being added onto it. But at the same point, I always take a settlement approach to try to get the best and lowest settlement possible. Whereas if you're sued by a junk debt buyer, like a LVNV, Midland, Portfolio, those are cases where you may have some stronger defenses. You may be able to take those cases to trial. I've done over 400 trials against junk debt buyers. Probably 99% are against junk debt buyers, not original creditors. I typically, like I said, don't take those cases to trial and usually don't recommend it unless you have a unique defense like identity theft or something like that. But if it's a junk debt buyer, you may have a better chance to get a much lower settlement or maybe even get the case thrown out altogether. So I'd be interested to hear in the comments if you have dealt with a junk debt buyer or original creditor lawsuit. Let us know how you did, what the approach was, if you're able to get it settled, maybe what the settlement was, what kind of percentage you were dealing with, and some different approaches that you took. I'd be interested to see how it all played out for you. If you're in the state of Arizona and you need help with a lawsuit, dealing with debt collection, wage garnishment, any of those types of things, I do free consultations. My contact information is below. I'd be happy to talk to you. Appreciate you all checking in today. We'll catch you next time.